Good morning, good afternoon, and good evening, everyone. It's a great pleasure to be having this conversation with you today. I am Fabio Morosini, and I'll be moderating this conversation. The topic of the conversation is international economic law by other means, normative implications of Chinese outbound investments. The role of China plays in the changing ecology of international economic law has been a source of great interest to the field. The emerging literature on China's legal order argues that the novelty of China's interaction with the existing legal order lies in the way that the country, while not abandoning the traditional EL tools, such as preferential trade agreements and bilateral investment treaties, crafts alternative regulatory spaces and tools to accommodate its interests. We sense that this literature is either focused on least developed countries, usually affected by the Belt and Road Initiative, or on the impact of China's rise on the incumbent powers. Our research and this conversation intends to shed light on the interaction of China's economic order with countries that lie in between these two extremes. And for lack of a better term, we're calling them upper middle income economies. Thus, this conversation aims at unveiling the features of Chinese approaches to EL, international economic law, in a selected number of countries by examining the legal tools mobilized to govern China's foreign direct investment in Brazil, in India, Nigeria, and Uzbekistan. We also included Australia in our project, arguably not an upper middle income economy. Australia has a history with China matters that falls outside the developed country narrative. And we suspect that insights from Australia can shed light on blind spots and be picked up by other countries in this group. This project is led by Michele Sanchez Badin and myself, two academics based in Brazil. We trust that EL, as experienced in some parts of the Global South, has special features that are not captured by mainstream literature. Like our previous projects, in this research, we also work to unveil these features, searching for EL in different spaces and tools. To join us in this ethnography of the field, we invited other scholars from the Global South with local experience to share their views on a set of similar questions, aiming at reconstituting China's bilateral economic engagement with selected upper middle income economies, while assessing their normative implications for the field of EL. We focused our conversation on three regulatory layers. First, government-to-government interactions, which we call the macro-level analysis. Secondly, we explore the domestic regulatory schemes and their role in facilitating or hampering Chinese FDI. And lastly, we asked the group to explore elements of FDI regulation at the private level, such as contracts and corporate governance structures. To join me in this conversation, we have Michele Sanchez Badin from FGV Law School in Brazil. We have Vivienne Bath from the University of Sydney in Australia, Manu Misra from FGV Brazil, Edefi Ojomo from the University of Lagos in Nigeria, and Alisher Umirdinov from Nagoya Keizai University in Japan. So to start this conversation, I'm going to ask the first question, and that is addressed to Michele and Manu. How has Chinese FDI impacted your country in the last few years? How does it compare to other major FDI exporters? And at the government-to-government regulatory level, is China and your country replicating standard agreements? And if not, in which respect do they differ? So, Michele.
Thank you, Fabio. And thanks, SIEL, in the name of Maria Laura, for organizing this meeting. It is a pleasure to be here with the audience and with our colleagues who accepted our invitation to join this new project. China as none is certainly the new dragon in the room. In the case of Brazil, a shock of investment from China in the period of 2010 to 2016 consolidated the idea that the dragon was arriving in the South American tropics. According to the China Global Investment Tracker database, China has invested 70% of its $61 billion in Brazil in that period. It was a fortunate moment to China. China was expanding globally its investment abroad. The developed economies in Europe and US, traditional investors in Brazil, were heavily affected by the 2008 financial crisis. And as from 2013, Brazil is under a severe economic and political crisis. So we had a hungry dragon and available hunting assets in the country. China became the largest investor in the country in that period. And it is considered the largest investor in the country after the European Union countries, the former colonizers of the country. So China destabilized the transatlantic pact of United States and European countries as largest investors in the country during the 20th century, bringing geopolitical and geoeconomic concerns to the region. So I guess that this is the first impact of Chinese investments in Brazil. Our research tries then to understand how much different are legal structures supporting Chinese inflows in Brazil to the ones supporting US and European FDI. Brazil, as we previously explored in our book, Reconceptualizing International Investment Law, has not signed BITs, bilateral investment treaties, and it does not have this new format of investment facilitation agreement, nor neither with US, European Union countries, nor with China. But China as a middle economy, differently from US and European Union countries, has signed a couple of cooperation agreements under different formats, aiming at coordinating specific economic agents, linking what we call it the macro structure of interstate arrangements to domestic regulation and their public agents, as well as certain economic actors from the private market. This is also a practice of Brazilian diplomacy. So macroeconomic regulation for Chinese FDI in Brazil is different from what we had for traditional investors, but very much familiar to the structures of agreements that regulate other Brazilian economic relations and FDI. The question now is to what extent such agreements potentialize and or limit the investments made in the country by China. So I'll leave more to think about in the next questions that Fabio will give to me. Thank you.
Excellent, Michelle. May I hear from Alisher now, please? Oh, sorry, from Manu. From Manu.
Hi, everyone. Thank you. Thank you to Maria Laura for organizing this. Thank you to Fabio and Michele for letting me be a part of this discussion. So if you're talking about standard agreements and whether or not in the India-China relationship they have been replicated, there is a 2006 BIT that was signed with in a sort of traditional manner, as we can call it. So with your substantive protections and guarantees, a dispute settlement mechanism via international arbitration. This treaty was unilaterally terminated by the Indian side in 2018. But it's still enforced, of course, due to a sunset clause, which I believe is about 15 or 20 years, and certain Chinese investments are still protected under that treaty. The reason for termination is, well, one would be it was inevitable anyway after White Industries versus India in 2011. So India set out on a project to cancel all of its bilateral investment treaties, to negotiate based on a new modern investment treaty from 2015. But I would speculate whether another reason for the termination was a border conflict that occurred just a few months before that date of termination in 2018, which in some sense resembles the broader economic relationship between India and China, where wider geopolitical issues have played in, and there's been a continued sense of suspicion from both sides, in fact. But to that extent, sort of your standard agreements have been replicated in the Indian context. But having said that, there's also been what would otherwise be considered non-traditional agreements, so MOUs, protocols, policy coordination, working groups. Most recently, there was what was called a strategic economic dialogue in 2015, I believe, after the Modi government first took office. They usually consist of, there's at the national to national level, subnational level, between SOEs and subnational, between SOEs on China's side and private entities on Indian side. So there's been a wide range of engagement in the MOU format between the Indian and Chinese sides across the last, say, 5 or 6 years. And we saw a major boom of Chinese investment in India around 2014, 15, 16, especially in the tech sector. And that, to my knowledge, and based on my impression from interviews, etc., was largely market-led and not state-led. And they had a meaningful development impact as well. And there was sort of, private entrepreneurs seeking the Indian market, and sort of India was the place to be for a lot of them because of the size of the market and the sort of potential in the IT sector. They would be what I would call sort of real impactful investments from the Chinese side, and they also have a sort of flip side of that, where the other impactful Chinese investments in India have been in the sort of small loan applications. There have been sort of microfinance or micro lending applications through sort of tech finance, and they have had an element of criminality to them, and there were some scams that came up in the latter half of 2019, and they got quite a lot of sort of coverage amongst Indian debates, policies, discussions. Now the question is, to what extent were the agreements and the MOUs that were signed between India and China have led to greater FDI from China to the Indian side, and B, how have they allowed or protected sort of interests in terms of responsibility of foreign investors, etc. I think so. Those yes. Traditional agreements have been inadequate in that sense. Thanks.
Thank you very much, Manu. I'll move to our second question for this conversation, and I'll ask Viviane to step in, and then Edefi. And the question is, which economic sectors have been mostly impacted by Chinese FDI in your country? And has Chinese FDI impacted or been impacted by domestic sectorial regulation, and in which ways? So Viviane, please.
Wow. Well, it's great to be here. Nice to see everyone. And I'll embark on this quickly. Historically, investment by Chinese companies in Australia, which really took off in about 2007, 2008, has been investment by state-owned enterprises, mainly in the mining, energy and resources sector. And those were where the really big transactions were. Over time, that's shifted. More recently, investment has been dominated by the private sector, and particularly in, since 2018, agribusiness, healthcare, and always commercial real estate, which I think is always very popular with Chinese companies. However, there has been a really big drop-off in Chinese investment from about 2018 to 2019. And there are a range of reasons which can be attributed to this. One is the passage in legislation in China, trying to stop state-owned enterprises in particular from engaging in what's so-called frivolous investment, that is sectors which are not encouraged by the government. But also, responding to your question about domestic sectoral regulation, there has actually been significant tightening in Australian regulation in relation to foreign investment. And a lot of this, although it's not specifically directed at Chinese enterprises, has a big impact potentially on Chinese investment. As you all know, of course, Chinese-Australian political relations and trade relations have been extremely poor over the last couple of years. So it's difficult to tell whether that's had an impact on investment. More likely, it is to some extent due to the fact that a new process of screening of foreign direct investment has been instituted. So state-owned enterprise investment has always been subject to no threshold screening. That is, every investment by a state-owned enterprise, sovereign wealth fund, foreign government-owned entity is subject to screening. But a new level of very tight national security screening has been instituted. And I think undoubtedly this is actually directed at Chinese investment of various kinds. And the reason is because of the interest of Chinese companies, and I'm sure Brazil and other companies experience this too, is the interest of Chinese companies in so-called infrastructure. So investment in not just power plants, but also the power grids, proposed acquisition of ports when they came up for sale, proposed acquisition of the gas networks and so on. All of these have been Chinese proposals which have been subjected to a high level of scrutiny and some of which have been rejected. Now, part of this is because of the policy of the Australian government in actually trying to sell off the infrastructure, which has meant that more of it is up for sale, and you would expect the Chinese to be interested. But certainly this has raised consciousness at the Australian government level of the role of national security in foreign investment. And you're probably aware, of course, in the context of trade, that the question of telecommunications, and particularly investment by Huawei, has been a big issue in Australian regulation. It is the federal government which plays the main role in terms of foreign investment policy. However, state and local authorities have a role in relation to coal, gas, and other exploration and development activities. And all this is a sensitive area, and a couple of Chinese companies have been involved in deals which have caused a great deal of kickback. The most recent refusal of an exploration license was in fact a Korean company. So I don't think we can say that that's something which is specifically directed at Chinese companies. And I'll stop there.
Excellent, excellent, Viviane. May I ask the same question to Edefi? So which economic sectors have been mostly impacted by Chinese FDI and the role of law in this process?
Hi, everyone. Hi, Fabio. Thanks for having me today. I'm going to leave my video off because I think my internet connection is a bit wonky. I'm sorry. I mean, I could try it for a bit. But if you don't hear me, I'll just turn it back off. Thank you very much. So in Nigeria, Chinese investment has been very interesting. A lot of it can be seen in infrastructure. And the development began in the late 1990s, and over the past 20 years, it's just really sped up. Mostly in transportation, with the Chinese government investing in building transportation infrastructure, railways, roads, in telecommunications, and very particularly in the oil sector. And these are some of the biggest investments that China is making in Africa as a whole. For instance, the investment in transportation by 2010 was over $2.5 billion, which was one of the biggest investments in transportation across the continent. There was also investments in telecommunications, geoengineering, electricity. The electricity sector is also another big recipient of Chinese investment in Nigeria. The legal framework for this is really around bilateral agreements. So the Chinese government has signed multiple agreements, and I guess I'll talk more about that later on with the Nigerian government to guide the general framework for its interventions in the country. And many of the financing activities have happened through the Export-Import Bank, with contractors coming in from China. So state-owned companies like the CCECC, the construction company, the Chinese Petroleum Company, and the National Oil Company as well. So there's a mix also of with ZTE and telecoms. So there's a mix of private and public sector companies coming into China, being the main contractors to govern many of these projects in Nigeria.
Thank you very much, Edafi. I'm moving to our third question of the day. And the question is, at the private sector level, who are the main actors involved in these transactions, and which legal arrangements are relevant to govern these transactions? So I'll ask the question I'll start by asking to Alisher.
Fabio, thank you very much. And thank you very much for having me here. Thank you very much for inviting me to this amazing panel. Okay, to answer your question, I want to raise the project relevant to the well-known digital Silk Road in Central Asia, in case of Uzbekistan. As you may know, the digital component became an increasingly important part of BRI, especially in the last 3 and 4 years. And I note that Uzbekistan is a very active partner of BRI, but digital cooperation between Uzbekistan and China requires special attention. I want to raise the special flagship project. This is the Safe City or the Smart City project between China and Uzbekistan. And Uzbek government concluded a $1 billion contract during the second BRI forum in 2019 in China. And now that this digitalization of Uzbekistan by Chinese tech giants are moving really fast. This year, August, I went to the home and I found no police in the street, because Uzbekistan was well known for numerous number of police, especially traffic police. But drivers were so afraid of traffic fines because there was, installed a lot of, traffic cameras. So in case of, first of all, macro level regulation, Uzbekistan has BIT with China concluding 2011. And also the government has strategic partnership with China. And plus the Ministry of Development of the telecommunication has signed agreement for cooperation, agreement of cooperation on Safe City project. So in case of mesa level regulation, yes, we have laws, we have regulations, but I want to say that as Edef mentioned, that the ZTE has some projects in Nigeria, but in case of Uzbekistan, the Huawei is the dominant player in Uzbekistan, and no ZTE, ZTE is a minor actor, I think, and it has so very large market in Uzbekistan, and with cheap Chinese loans, it has already dominated. And on the other hand, our investment law and especially the competition law is quite fragile, and the government has huge discretionary power in granting the license or concluding investment contracts. That's why I don't expect too much in case of the mesa level regulation regarding the Chinese investment. But let me jump on to the micro level, private level regulation. The main legal tool in case of digital Silk Road between China and Uzbekistan is a contract, especially between Chinese tech companies and not domestic companies, but Uzbek government and Uzbek state organs. And so Chinese ICT companies directly work with Uzbek government. And during my interviews, I noticed that they have a huge, negotiation power, and they have a huge experience. That's why in majority of cases, Uzbek government and officials are following them up in these contract negotiations and standard making. And although there wasn't any ICDS or commercial disputes, but in previous years, there was a huge payment issues in case of Chinese parties. Therefore, I heard that the Chinese companies are trying to get government guarantees in case of concluding contract with Uzbek government. And in case of labor issues, Central Asian countries are well known for their strict visa requirements against Chinese nationals. But in case of Huawei has a subsidiary in Tashkent in Uzbekistan, and it has around 150 workers, and 80% of all workers are from Uzbekistan. But the final issue is the security issue. Since there are some evidence on the relationship between the Chinese tech companies and Chinese state, there may be some fear of the Central Asian states that all data obtained through technologies that Huawei installed in Uzbekistan will be managed in data centers in China and maybe streamed to the Chinese state. On this case, Uzbek parliament adopted the personal data protection law, but there is no available information on the data protection issues. And the final point is that I think that the Chinese tech companies and Huawei, they usually collaborate with Uzbek government, especially security forces, because in case of Uzbekistan in 2012, there was a very interesting issues because the Uzbek government, abruptly deprived the license of the largest telecommunication operator, MTS, and this case elevated to the multi-billion dollar case in ICSID. That's why I suppose that the respecting the digital sovereignty of the host state and Huawei and other Chinese tech companies, they time to time collaborate with Uzbek government, and maybe for this reason until now there was no big scandal with Chinese companies in digital field. Let me stop here.
Excellent, Alisher. Thank you. So let me ask the same question to Michelle in relation to Brazil. So at the private level, Michelle, who are the main actors involved, and which legal arrangements do you perceive as being relevant to govern these relations?
Well, we have to understand that 70% of Chinese investments in Brazil are still concentrated in the energy sector. So then we come to the question, who are the investors? And as Vivian previously mentioned, in the case of Australia, it happened the same. It was replicated, the structure in Brazil, where they have the large state-owned enterprises from China investing in Brazil. So our first exercise as a case analysis, we had chosen to scrutinize the largest transaction of Chinese investments in Brazil. That was the acquisition of an electric energy group, that is CPFL, a private group in Brazil, by State Grid, a large SOE from the energy sector in China. That happened in 2016, 2017. CPFL case is interesting because it was the largest takeover, as I've mentioned. It was about $8.3 billion, the transaction. There was a relevance of the company in its sector of activity, so that we could understand it as critical infrastructure. And there is a strategic relevance of its activities in providing public service to the most populated and industrialized region of the country. So definitely we are talking about critical infrastructure in this case. So CPFL was understood as an interesting laboratory for thinking about this three-level axis of analysis. And we decided to have this ground-based analysis of that. We had a question about how it has impacted the domestic regulation and what is the role played by local regulators. So then we try to understand that, looking at formal and informal regulation and relations, public and private transactions, documents that we understand the legal formats that would be governing those specific transactions. So when we go to the macro level, as I've mentioned, under those cooperation agreements in Brazil, increasingly what we had was the start of having 10-year planning agreements signed by the countries. So that was an adoption of the planning language from China in those agreements. And energy was elected and was mentioned as one of the main and the most important sectors and the Brazil-China economic relations to be strengthened and to be developed. So the agreement signed between Brazil and China, they were clear in appointing the sector, in naming the companies that would be taking place. So state grid is part of the language, the words of the agreements, and the financing structures for those operations. So we have kind of the design of the operation that was brought to the agreements, to the interstate level of the agreements. When we go to the meso level, that is the domestic regulation, we have to understand that that was an important inflow of Chinese investments in Brazil, but Brazil as a middle economy is highly dependent on foreign direct investment to develop its critical infrastructure, and is also dependent on the technology to support that infrastructure. So it is part of the Brazilian energy sector to count with foreign direct investment. The system was designed to have those foreign direct investment. So, and then we noticed too that China is not the only country investing with its SOEs in Brazil. We have other countries, Nordic countries, that invest through their SOEs in Brazil, and even traditional European countries. They have a high level of participation of the state in the companies that have invested in Brazil, especially from Italy and France and Spain. But what is happening is that China is also acquiring those investments in third countries. And for example, the acquisition of EDP, that is a Portuguese company in the energy sector. And then that also has had an impact in Brazil, an indirect impact in Brazil. But then the regulation of the sector, the energy sector in Brazil, is designed for this foreign direct investment. And we have a national agency that controls and supervises the investment and also the operation. And there is also a system of controlling the market, the process of buying and selling energy, that is also controlled in the company, in the country, with the concern of not leaving any problem of lack of energy in any region of the country. So there is a very, very well regulated, at least over the interviews, we understood by the operators in the sector that they are very much confident that this domestic regulation is enough to control any foreign investment in this critical infrastructure in Brazil. And it is not possible to have, even considering any sort of impact for financing or any sort of subsidy for Chinese SOE investments in the sector in Brazil. There is a small concern about the change of technology standards that can come together with the Chinese investments. So, and then with that technology, we also think about private standards that came together with those new technology. So this is one of the points that we are trying to understand better, to what extent it may change the market structures. So when we may I just the micro level, that would be the concerns that we could understand about the private agents, how would perform their role. We understood that the main concerns from the operators of the system was about the governance structure of the companies. Would CPFL Group keep the same governance structure? It was an open company and it was very much transparent in its operations. And then we had one point that would be the change of the management structure. in CPFL, not only for Chinese names, but also for what we call the shadow governance, for names that were not part of the statutes of the company, but they were playing a role in the company. Then we undertook a series of interviews with people working in the company and that had worked previously in the company. And we understood that the role of those names that have been speculated as like suspicious names that could be linked to the Chinese Communist Party or any political influence, we understood that, in fact, they were kind of middle-level names that were having more a technical role than instead of a political role inside the corporate governance structure. So we didn't notice any sort of political influence that could be an alert for the way that the company was operating. And that process of closing the company, and it is a process that we also notice when it happens that other foreign agents acquire a company in Brazil and they normally go to a subsidiary system as China did. So there was no novelty on that sense. We understood that the most relevant concern for us is linking this micro and meso level is about the private agreements that could be setting standards and have any impact also in the trade flows and the technology dependence of Brazil to China. Thank you, Fabio.
Thank you, Michelle. So let me move to our fourth question of the day. And which is which mechanisms have been developed or used to address issues arising out of China's FDI in your country? So I'll start asking Manu in relation to India, whether there are such mechanisms and which are they?
Sure. So I would divide the regulations or mechanisms adopted in two parts. First one was in April last year, where the DPIIT, the sort of Department of Promotion of Investment and Trade, etc., from the Ministry of Commerce, they put out a press note, which is a sort of executive decision to include all border countries in the list of sources of FDI that would require mandatory government approval, looking at ultimate beneficiary of the investment. And so by all border countries, what that effectively meant was China, given how it was already the case that Pakistan was on that list as a mandatory government approval country. And the background to that decision, I think, is important because there was this growing sense within policymakers that a lot of Chinese capital was entering India undetected, sort of under the radar, partly because of VIE structures, partly because of just via Hong Kong, Mauritius, Cayman Islands, etc., so tax havens. The other sort of growing sense amongst them was that some of this undetected capital has an element of criminality to it, which we saw in some high-profile scams in the end of 2019. Some arrests were made later on, and a few $1 billion was implicated in that. And the trigger event, however, was the pandemic and the sort of reduction in valuation of some high-profile banks and companies. So what happened was HDFC is a major bank in India, and the People's Bank of China increased its shareholding to 1%. And that immediately triggered a sort of panic within the government, and they released this press note. It's easier said than done. It's not very well drafted. We are expecting more legislation, perhaps an act on it to sort of clarify what the definitions are. I'll not get into right now, but it's a flawed approach so far because it's unclear. Arguably, that's the objective, that by making it unclear, they're allowing more discretionary power. But we'll see how the practice develops. Approvals are backed up at the moment. You know, one case of foreign investment that has been diverted to Brazil, incidentally, Great Wall Motors, that is, in the automobile sector, because of delays in the approval process. So there is a question of how India will deal with the sort of backlog of FDI approval applications. We also know that they are still approving, and in fact, I've seen a document where they've approved a certain FDI in Mumbai, I believe, with certain conditions. So the question is, what sort of conditions are they applying? What's the criteria? How will they monitor, enforce, etc.? But I have to emphasize that at this point, the debate was largely unanimous or sort of consensus that it's still business as usual. Come June 2020, we have the Galwan border conflict. There are mortalities, 20 of them in India. That changes the mood of the country. I mean, then you had a unanimous bipartisan consensus that this is no longer business as usual, and that China has modified the modus vivendi of the China-India relationship. And that took a turn in a normative sense. The first victim of that was Huawei, despite being, I mean, to be fair to them, thousands of Indians are employed in Huawei India. It has had a significant development impact, and it's a really quite a tricky situation the government of India found itself in. But the first victim of that was Huawei, because of the 5G trials. They passed what was called the National Security Directive, under which equipment suppliers to Indian telecom companies were required to be approved via what was called a trust portal. So the concept emphasized here, as vague as that might be, was trust, in which case, so far as we know, Huawei has not been given approval while Ericsson, Samsung, Nokia have. Which just goes to show that when there's a trust issue between the government of India and the government of China or the Chinese Communist Party, Huawei was not recognized as an independent entity. And that sort of carried over into how Huawei was perceived, despite the impact that it had in the Indian tech sector. And interestingly, they also liberalized the telecom sector at the same time. So they said 100% equity can be owned by foreign investors without any approval required. It can go direct to the automatic route, what's called, right? Unless you are a border country, which is therefore China. It could be Bangladesh and Bhutan, Nepal, etc. But I mean, we know it's mostly China that's being targeted. Other things also followed, what we can sort of call as a selective decoupling in a sense. Tenders were revoked, public procurement rules were modified, highway contracts were canceled, joint venture MOUs were put on hold, apps were banned most famously. But it was clear that the issue of what's happening at the border, what's happening between the two countries' governments cannot be sort of kept separate between what's happening in the economy. And there's a sort of recognition of what's called economic security. And if I can just add the last point, there's also it's also continued now in 2021 with sort of crackdown on China-backed fintech lenders. Now law enforcement agencies have been involved. The Reserve Bank is now reviewing its regulations and monetary policy. Immigration rules are changing to sort of try to sort of have some control of what kind of capital is entering India. It's easier said than done. It's very difficult to sort of actually track what, where, and how money is coming in.
Okay, thank you, Manu. I'll have to stop you here because we still need to hear from Viviane. So Viviane, would you please address the same questions? Which mechanisms have been developed or used by Australia to address issues arising out of China's FDI? You're on mute, Viviane.
There we go. I've already addressed some of them to some extent. I mean, on the face of it, Australian legislation is facially neutral, but undeniably there are certain aspects of Australian legislation which may have a more substantial impact on Chinese investment than on some other types of investment. In addition, in relation to the way in which Australia has negotiated its free trade agreements, there's disparate treatment of investment from different countries depending what period the investment treaties were actually negotiated. So, for example, in terms of US investment, that was the first FTA, and they got very substantial benefits in terms of in terms of the thresholds that would be applied to their investments. And of course, they don't really have state-owned enterprises, they're all private businesses, so they can come in really virtually without scrutiny, not completely without scrutiny. One of the biggest acquisitions proposed by a US company was in fact knocked back. But by the time we got to Japan, Korea, China, the government of the time had become very anxious about foreign investment in the agricultural sector. So those thresholds for review of proposed investments in agriculture were taken down to $15 million, which is actually a very low level in terms of trying to buy up a farm or a substantial block of agriculture or agricultural business. And it was in fact a Chinese proposal to buy the largest landholding in Australia, which was knocked back on the basis that it was contrary to the national interest. So you could say that the Chinese were more severely impacted by that. On the other hand, a proposal by a Chinese business to buy Australia's largest agribusiness for $1.5 billion Australian dollars was approved. So it's difficult to say that it's particularly something which affects the Chinese, but it may have more impact on them because they've got more state-owned enterprises and because, as I mentioned, because of the sort of things in which they wish to invest. Now, areas in which I think that Chinese investment has had an impact on the way Australia's process works is the use of undertakings and conditions when investments are actually approved. These used not to be particularly common, but since a lot of Chinese investment started coming in, you'd see more and more conditions imposed on Chinese investors. And these would be things like requirements to have local directors, sometimes obligations to have a public listing of the shares in the entities, sometimes requirements that the actual investment be dropped to a minority holding rather than a majority holding. There's also been an increase in post-investment monitoring. And this was, I think, directly due to Chinese investment in private real estate, that is homes and apartments and so on. Australia, like other developed countries, I think has been a very popular destination in that way. And so I think that Chinese investment is not necessarily hindered more than anybody else by this, but certainly they have been the cause of some of these additional restrictions being brought in. And that applies to other sorts of monitoring requirements that have been brought in too, in terms of tax registration of interests, a water register, and so on. In terms of straight out refusals of Chinese proposals, the Australian process is to have case-by-case review of investments, and this obviously gives the government of the day considerable discretion. And my last point here is that with the change of our legislation to place considerable emphasis on the idea of national security, as opposed to a more general test on the national interest, I think that we may well see that more Chinese investments do find themselves being knocked back specifically on the national security ground.
So let me move to our final question that we had for our speakers today, and which is a more, I would say, general overarching question that sums up our conversation. So the question is, from your analysis, is it possible to talk about the emergence or consolidation of a Chinese approach to international economic law order? And if so, what are their defining features? And I'll start asking this question to Edefe.
Thanks, Fabio. So, I mean, when I'm reading the literature, when I'm going through the agreements, there's obviously the tendency for me to think about my own research and the direction that my research has gone in the past few years. And I think what's amusing to me is the sense that on the very broad scale, a lot of the Chinese engagements have been on the basis of some kind of solidarity, right? So these investments are somewhere between regular trade agreements and development intervention. And I mean, for the past decade or two, we've talked about, you know, Chinese interventions and what they mean. and how different they are from regular ODA, and now speaking about how different they are from traditional practice in international economic law. There's a sense that there's some kind of mutual assistance that's going on between the countries, that's grounded in solidarity, but also in the technicalities of these agreements. So the technical agreements, like the BTA, they're very standard. So the regular provisions on repatriation of funds, on expropriation, access to information. So the technicalities are pretty much the same, but surrounding that are also agreements on mutual interest, mutual support, and generally the language of brotherhood. So it's everything is done around the context of the diplomacy and the broader political and social cooperation between the two countries. But very recently, since last year and the COVID pandemic, the beginning of the COVID pandemic, and just really the outcry against anti-Black racism in China, people began to think and talk more about the basis for this solidarity, right? So the focus then would shift from the more technical aspects of the agreement to the brotherhood that's centering these international economic arrangements in the countries. So that's the big thing for me. Just because I study solidarity, that's the big thing for me is, where's solidarity in these arrangements? China has, I think China's first strategic partnership was with Brazil, and they have all these strategic partnerships that underpin their relationships with all these other countries. And there's a strategic partnership with Nigeria. That's a strategic partnership featuring mutual political trust, mutual economic benefits, and mutual support in international affairs. So the language is pretty much around the lines of what I would call solidarity. So that's the first thing. And then the second thing, which I think a lot of people have spoken about over the years, is really where the mutuality comes in, because there's a lot of Chinese investment coming into Nigeria, a lot of Chinese business coming into Nigeria, setting up in Nigeria. And so at that macro level, you can see how China is coming into the country. I mean, they are building infrastructure and contributing to addressing the infrastructure deficit in the country, which, I mean, it has been said they're doing across the entire continent. But the level of neutrality on the other side isn't as strong. So that's the thing everybody has been talking about. It's mostly small businesses and small business people that are moving to China to try and do business at that migrant level. So those are the two things that at this point I'm looking to point out in my research. But in terms of regulation, I'm still trying to figure out, where the real difference and the real change is.
Great, thank you, Ajafe. May I ask the same question to Alisher? So do you consider that there is such a thing as an emerging Chinese approach to international economic law order when you analyze it from the experience of Uzbekistan?
Mm-hmm. Thank you, Fabio. Actually, I have two short, quick points on this issue. First is that it's a flexibility of Chinese government, and the second is adaptability of its IT giants, IT companies to local conditions. Let me explain each of them one by one. First, Uzbekistan's situation is very interesting. It, to some extent, closely resembles the Brazil. Yes, different from Brazil, we have BIT with China, but Uzbekistan is neither contracting party to the WTO, nor it has FTA with China. But both parties, if you look to the practice, they are doing quite well under the so-called MOUs and cooperation agreements, which lack normativity. So they are so-called, basically soft law instruments. So interestingly, it shows us that against mainstream international economic law trend, being flexible, China proves that it can integrate and do business with countries even without hard law treaties. So this is the first point. And the second is the adaptability of its companies to local conditions. More importantly, being a leading supplier of surveillance technology, China and its ICT companies adopt tactics which are very, to some extent, difficult to regulate through traditional international economic law tools. This may be a very specific feature of foreign economic policy of the Chinese state capitalism. Even with lots of legal grievance in host countries, for example, in case of Huawei, Huawei does not use ICDS or commercial arbitration against state organs or companies. And in tandem with the Chinese state's unconditional soft loans, for instance, Huawei works very well with already well-established local companies. And it also generously organizes so-called digital Silk Road tours for government officials to China, grants digital Silk Road scholarships to the local universities and local university students as well, and finance short-term overseas, especially to the China training courses. And in the last years, it's increasingly trying to open the research and development centers in the host state universities. So in case of China, it's very interesting, different from the Western countries and Japan and Korea to some extent. The aid is going in par with very active business. So to conclude, relying on international economic law by other means, China and its tech giants are gradually wiping out traditional IT champions and changing the main digital roads towards Beijing. Fabio?
Thank you so much, Alisher. There are plenty more to be talked about concerning China's economic interactions with what we are calling the upper middle income economies. And of course, the last question is a broader question that is being currently addressed by us in this project, where we are trying to understand whether there is a Chinese international economic law order that is different from existing ideas of orders, and whether the connection between China and upper middle income economies bring a novelty to the table and can contribute to the emerging literature on China's bilateral investment relations. We wish to continue this conversation. We're open to further discuss this issue with people that are potentially interested in this field of inquiries. You can all contact us by using our emails that is up in the flyer information for this conversation. I will thank very much all of the participants for today's very interesting conversation. And last but not least, let me also thank the organization of the conversation. And I do that in the name of Maria Laura Macedo. And we are wrapping up, and we hope that you have enjoyed, and we will see you in our next meetings. Thank you and have a great day.
Thanks, everyone.
Bye.
Thank you very much.
Thank you.